very good afternoon to one and all present here. I am Devanshi Vyas from the 35th course BHM and I will be your MC for today. It is my absolute pleasure to welcome respected Vice Principal Mr. P. Rajshekhar, our guest speaker Dr. Nanda Kishor MS, faculty members and my dear colleagues from BHM, BACA, MSc DAN and MHM to today's talk on the occasion of the Samvidhan Divas, the Constitution Day. Thank you all for joining us for today's event. Today, the 26th of November, is celebrated in India as the Constitution Day. And to commemorate this occasion, we have Dr. Nanda Kishore MS with us to talk on the topic Envisioning Constitution as a Live Document. To start the event off, I would like to request our beloved Vice Principal, Mr. P. Rajshekhar, to brief us on the event and address the viewers. Over to you, sir.
Very good evening to one and all present here. A very warm welcome, Dr. Nanda Kishor, Associate Professor, Department of Geopolitical International Relations. I would like to welcome you on behalf of WGSHA, sir. Dear students, we are here to celebrate our Samvidhan Divas, that is Constitution Day. Perhaps you all know Constitution is a very important document and all of you should know about it. It should not be confined to a chapter in civics, but you all should know how a constitution operates, what is the importance of a constitution to our country. And we are one of the lucky countries who have been declared as a republic. And Dr. Ambedkar was the architect for making our constitution. And since April 2015 onwards, we have been celebrating this Constitutional Day on November 26th. And that is the reason we all have assembled here. And I would like Dr. Nanda Kishore to throw more light on the Constitution. And over to you, sir. And a warm welcome once again.
Thank you so much. And it's always a pleasure to get connected with each of you. Does the MC want to say something?
Yes, sir. Yes, sir. Yeah. Thank you so much, sir, for your wise words and delightful opening. Moving forward, I would now like to introduce today's guest speaker, Dr. Nanda Kishore. Dr. Nanda Kishore MS is an associate professor in the Department of Geopolitics and International Relations and coordinator of Center for Polish and Central European Studies, Manipal Academy of Higher Education, Manipal. He holds a Master's of Philosophy and PhD in Political Science from Hyderabad Central University, Hyderabad, India, and completed postdoc at the University of Leiden, Netherlands, with Erasmus Mundus Fellowship from the European Union. He has been teaching geopolitics of West Asia, India's foreign policy, concept of war and peace in geopolitics, terrorism, and asymmetric conflicts. Dr. Kishore has been working on conflict resolution, West Asia, Middle East, refugees, and international law. He was recipient of the short-term Junior Research Fellowship from UNHCR, Brookings, Government of Finland, and MCRG, Kolkata. He visited Hochschule University of Applied Sciences, Bremen, Germany, on a short-term fellowship by the DAAD-sponsored program of HS Bremen in 2012. He was the part of the International Visitor Leadership Program, IVLP, by the United States during June to July 2013. He is a senior fellow at the Defense Research and Studies in India, non-resident fellow of the Middle East Institute, New Delhi, advisor and subject expert for Covents, a Bangalore-based risk analyst company, analyst at Islamic Theology of Counterterrorism, London, visiting fellow to AIDIA Kathmandu, feature editor of Security Studies of Science, Technology and Security Forum, MAHE. He has several publications in journals and edited volumes. We welcome you, sir. The floor is all yours now.
Thank you so much, Divyanshi. That was a kind introduction. My special thanks to my good friend, the principal of the college, and then the vice principal, and my other two good friends, Mr. Valsraj and then Mr. Raghavendra. They've been kind enough to invite me to interact with you people. I used to regularly come. I still believe the live forum is always not like this one. I meant to say the offline forum is always much more effective because I can see the expressions on people's face and then subsequently alter or made modifications and accordingly custom make my presentations as such. But nevertheless, we learn to live with same like that of the Constitution as the time has changed and it has been a living document. In the same way, we have also learned to live with the conditions, and then we have been trying to do some of these things. So thanks to all of you for being here, and whatever that I know, a minimal that I try and love to share with you people. I have a small presentation which keeps at least it much more lively than just listening to someone like a ghost voice. So I'll try sharing the presentation. I think I'll take off my video for a few minutes. It will be much easier for me to share the presentation.
Sir, you can keep your video, sir, no problem, and also PPT. Both will be shown.
Okay.
Okay.
Yes, I'm doing that.
Yeah.
Is it appearing now?
Perfect.
Okay. Okay. The title of the presentation that I have today is Envisioning Constitution as a Living Document. When we say something as a living document, it's always an intriguing component, in the sense there are some who will have this apprehension when we call something as a living document. Does it allow for too many amendments and lose out its original content or the idea itself behind the Constitution or the philosophy behind the Constitution? But on the other side, we also see this one as a progressive document or a progressive institution that leads to from the time that we have started. There are several examples that I can give, because some questions that I try answering here is that our Constitution is so good that it needs no change, is the first question that I'm asking. Second, was it that our Constitution makers were so far-sighted and wise that they had foreseen all the changes that would take place in the future? Third, have we inherited a very robust Constitution? Is it rigid or flexible Constitution? Now, these are some questions that come into mind whenever I'm talking about something associated with, let's say, Constitution as a living document, because first and foremost is there is no Constitution in the world that has not been changed, or there's no Constitution in the world which can be called as perfect. It has its own limitations. There might be in frequency, there might be difference between certain constitutions. The basic framework of the Constitution is very much suited to our country. There is no doubt about at all, because our Constitution makers were far-sighted enough, in the sense same like that of the Vedas. In the Vedas also, the opening remarks very clearly says, let the knowledge come from any part of the world. So that's what Indians tried doing, because we didn't have a great legacy that's associated with constitution making. That means a system that worked differently than that of the of having princely states, or for that matter ruled by someone else. Though we were one of the earliest republics in the world, we had republics during the time of Kautilya or Chanakya, whom we call. But apart from that one, we lost that tradition where the idea behind republic, when I say republic, is simply a state where the head of the state is not hereditary. That means it's chosen in direct or indirect form, depending on the capacity, what's good for the nation, just not what is hereditary at all. That's precisely a reason why we don't call UK, or for that matter Canada or Australia, as republics, because they still are under the constitutional monarchy. They continue to run their government based on constitutional monarchy, whereas India is a republic. We don't have a family ruling or something that's coming from as a head of the state, something coming from one to the other. Third, there's no constitution in the world that can provide for all the eventualities. In the sense, as the societies have progressed, we have also progressed with the type of documents that we are coming in the sense, for a long time, because we have always this distinction between the original truth or the permanent truth and the constructed truth. The constructed truths are the one which lead to eventualities. What we thought 100 years ago was never an issue is an issue today. Let's say, for example, LGBTQ. Right now, LGBTQ was never an issue even when the constitution makers were sitting in the Constituent Assembly. They never thought there was a necessity to deal with it or keep something open for that one. right? Second is also we looked at same-sex marriage, or for that matter, live-in relationships. There are many other components that have been spoken in the present day, which were not having any space in the Constitution. You don't find the Constitution actually speaking about any of these things. And nevertheless, Constitution is also not a document that would talk about anything and everything in every walk of life. It has something else to do with, in the sense it limits itself as a book that can give us a basic framework, and then based on that one you need to build upon. That is when it becomes a living document. So there is no such document, as I told, that it can provide for all the eventualities, and no document can be such that it needs no change at all. There are limitations which needs to be understood. Just let me quote a couple of people who are very, very important to the Constitution. One is Dr. Ambedkar, on whom we remember today as the chairman of the drafting committee. And then you had the galaxy of people who contributed in all sorts of ways. It's not that Ambedkar alone could do everything. There were luminaries in law who could speak about the whole criminal procedure, who could quote from any of the texts that were associated with the British to everything. Such type of people helped, in fact, even Ambedkar to look things from different perspective. Now, Nehru in the Constituent Assembly made this particular statement where he said, while we want this Constitution to be as solid and as permanent a structure as we can make it, nevertheless, there is no permanence in constitutions. There should be a certain flexibility. If you make anything rigid and permanent, you stop a nation's growth, the growth of a living, vital, organic people. Therefore, it has to be flexible. Otherwise, let's imagine what he's saying, like living, vital and organic people. If we don't accommodate certain demands of a present condition of a society, there would be revolutions. That revolution will disrupt the whole walk of life. That can be very, very problematic. So he says, therefore, it has to be flexible. In any event, we should not make a constitution such as some other great countries have. He was essentially referring to the United States, because the United States has had least number of amendments if you look at in any part of the world, one of the most stable constitutions, and also comparatively a rigid constitution for all known reasons. We should not make a constitution such as some of the great countries have, which are so rigid that they do not and cannot be adopted easily to changing conditions. Today, especially when the world is in turmoil and we are passing through a very swift period of transition, what we may do today may not be wholly applicable tomorrow. Therefore, while we make a constitution which is sound and as basic as we can, it should also be flexible. This is what he reflected in the Constituent Assembly, because Constituent Assembly sat through for 166 days in a span of more than 2 years. They took their own time because people had to be represented from all walks of life in different parts of the country, and then all of their demands had to be accommodated. So how do you really do, especially when you are a diverse country of this sort, right? You have so much of diversity that you cannot accommodate everyone. If you do something to someone else will be unhappy with it, and then you cannot accommodate everyone. That's not the way public policy functions. It's an authoritative allocation of resources. And in such scenario, some will feel bad and some will agree on the particular component. Now, the draft constitution, this is what Ambedkar said, has eliminated the elaborate and difficult procedures such as a decision by a convention or a referendum. It's only for amendments of specific matters, and there are only a few, that the ratification of the state legislatures is required. All other articles of the Constitution are left to be amended by the Parliament. He simply is talking about saying that I have not given you people as a chairman of the drafting committee. I've not given you an extremely rigid constitution, but a constitution that you can reflect upon. And at the same time, you need to make sure that the interest of the state is also taken care of. These talk about that the leaders or the individuals who are involved in making the constitution were aware of the type of challenges that the future India would pass through, and what is the necessity to have such type of a one. Now, for example, the Soviet Union had 4 constitutions in its life of hardly 74 years. 1917, we had the Bolshevik Revolution, and subsequently the Tsars were wiped out. Nicholas II was removed from Russia, and then the Bolsheviks came in, and then the birth of Soviet Union happened. So they had a constitution in 1918, 1924, 1936, and 1977, and then subsequently In 1991, the Soviet Union itself got disintegrated. That's a collapse of the Soviet Union. But after all those things, when the Russian Federation came into picture, again they had a new constitution in 1993. Now you must be thinking, after 5 different constitutions or 6 different constitutions, how Russia is still able to manage, right? That's an instability. That because Russia was humongously power hungry, humongously it was power thirsty. So that led to this type of problems. Now, whereas in case of India, first, Indian constitution accepts the necessity of modifications according to the changing needs of the society. Second, in the actual working of the constitution, there has been enough flexibility of interpretations. That is how you will see time and again the Supreme Court tries to intervene and tries to speak about certain things and says, no, this is probably not the way, this is the real way. We will see when there was a major issue about how and what can be demanded or what can be amended in the constitution, what should not be amended. Thirdly, both political parties and the judicial rulings have shown maturity and some amount of flexibility in implementing the constitution itself, because at the end of the day, the judiciary cannot, or it's not supposed to by law, say about a law whether it is good or bad. Its job is to say whether it's in compliance with the constitution or not. That's the job of the judiciary. So the job very clearly lays with the legislature and then followed by the implementation by the executive. In that scenario, the judiciary is sort of guardian of our rights and our duties, many other things that are associated with the constitution itself. Now, these factors have made our constitution a living document rather than a closed and a static rule book. Now, it's a document made by human beings after all, and may need revisions, changes, and re-examination. That's what we are trying to understand here on the Constitution Day. Now, the issue of amendment was one of the least debated and the most controversial subjects in the Constituent Assembly debates itself. If I have to look in, there were people who were luminaries, as I mentioned to you. You had Nehru, you had Sapru, you had K.M. Munshi, K.T. Shah, you had Panikkar, Ambedkar, all of them extraordinary in their way of looking at it. So it was B.N. Rao, one of the legal luminaries of India, who proposed some sort of amending procedure. He said the amendment should first be passed by a 2/3 majority in both the houses of the parliament and then ratified by a similar majority in the provincial legislature. Second, he said the transitional provisions may be amended by a simple majority in the parliament. But after going through all sorts of deliberations and practices, they thought that this was very, very problematic. Not everything and anything could be taken into, but some provisions were taken into, and then they brought it under Article 368 of the Constitution, which itself got into a lot of controversies. Now, there are a lot of constitutional experts like A.C. Ware who complimented the constitution framers of striking some sort of a fine balance by protecting the rights of the states while leaving the rest of the constitution to be amended easily. Because if you make the amendments and everything too easy, then also people will fiddle with. We had a whole regime which, like a fancy dress, it kept changing the constitutional provisions, it kept amending in one or the other way, which became very, very problematic. Whenever such mistakes would come into light, let's imagine that they tried and then there is some sort of an error. They wanted the constitution to be easily amended and to be able to get rid of these mistakes. Then there were some provisions in the constitution that were of temporary nature, and it was decided that these could be altered later on when the new parliament was elected, like the provisions that are given for the elections to the scheduled caste and scheduled tribe. Now, every 10 years it gets extended, and that's been going on, which they thought was a temporary provision that was available. Now, but at the same time, the constitution was framing a federal polity, and therefore the rights and the powers of the states that could not be changed without the consent of the state. That's why we have the upper house of the parliament, which is called the Rajya Sabha. Now, it has to also go through the Rajya Sabha, which is important. Now, some other features were so central to the spirit of the constitution that the constitution makers were actually anxious to protect these from the change itself. Now, these provisions had to be made very, very rigid. Now, these considerations led to different ways of amending the constitution itself. If you look in, the first component is similar to ordinary law, where we have simple majority in the parliament, as mentioned in some articles of the constitution. Then you have special majority in parliament in both the houses separately, as per Article 368. And then some of them are very important, where let's imagine there is a scenario that directly is going to affect the states, there where you require special majority plus the legislatures of half of the states. Something like GST we looked at, right? I thought we need to give as many examples as possible, otherwise constitution can become a very rigid sort of a subject to even talk about, because we need to be aware of our own constitutions. Like the GST, goods and services taxes. Now it had to be because it was affecting the states, because one nation, one tax was spoken about, and the states were fearing that they would end up losing a lot of money which they were getting before in the form of state tax, and then you had the central tax. Everything was coming in and they were free to impose taxes, though it continues to remain partially to an extent. But there was this particular issue that many of them feared. So then it has to get ratified by half of the legislature. So 15 different places, or 15 or to 16 places, or 16 states, the legislation got moved, and that's how GST got passed in. So this is one of the examples I'm citing, but there are many other examples that are there. Now, as I mentioned to you people, let me skip this simple provision that we are talking about. Now, to amend any of the articles that are there in specifically some of these portions, if we have to look in chapter 4, part 5, and many of those till chapter 11, one requires a lot of other provisions too. The amending bill is not only to be passed by the majority of total membership in each house and the majority of not less than 2/3 of the members present and voting in each house, but a ratification by at least 1/2 of the state legislatures. That's what we said. In the third one, we have the constitution that can be amended by a simple majority. Now, example is formation of new states. We looked at recently how the reorganization of the states happened. Those of you from Andhra Pradesh would know Andhra Pradesh and Telangana, 2 states were created because alteration of the state boundaries, changing name of the states, or delimitation of the constitution apart from qualification for citizenship and quorum in the parliament, all these are central subjects. In the sense, India says India is a union of states. That's how the first Article 1 begins with. But then subsequently, you will see most of these functions are associated with the union government, just asking that they need to consult the states, at least half of them, before they do some of these things. That means some amount of ratification that has to happen. Now, Ambedkar also exemplary made this particular statement, and he said, while the Constituent Assembly debates were going on, because quite a few of them were disappointed, or some of them were dissatisfied, saying that, oh, no, these procedures can make it rigid and it can create sort of a problem. How do we see Constitution as some sort of a living document? Ambedkar said those who are dissatisfied with the Constitution need only 2/3 majority. If they are not able to obtain even that, their dissatisfaction with the Constitution cannot be deemed to be shared by the general public. What he simply says is, or throughout the philosophy of the Constitution, is that it's people's will, and it's the people who will decide. Though we don't directly decide, we elect a regime or a political party to represent us, and through them we put up our aspirations. These are the sort of constitutional amendments that happened. You can see here that's between 1967 to 70, and then 77 to 80 when the Indian National Congress was there. That's Mrs. Gandhi was there. There were numerous amendments that happened. Again, we see between 1999 to 2004 also quite a number of amendments happened. Now, amendments most of the time have to happen through political consensus. Now, there is a large group of amendments that have been made as a result of the consensus among political parties. It's not that they've had an issue with regard to that. Now, consensus made it necessary that some changes had to be made in order to reflect the prevailing political philosophy and aspirations of the society itself. Now, if you look in many of the amendments post 1984, periods are instances of this particular trend itself. One of them is Antidefection Law. Now, all of you are aware the type of horse trading that happens whenever there is an election, and then subsequent to the election, when a single political party or a coalition does not get the numbers, and then immediately the resort politics begins, and then horse trading, people move from one place to the other, or in between there are tendencies where people jump from one to the other political party. That's how the phrase Ayaram Gayaram came, because of one particular individual. He kept changing his parties every now and then. This is when they had to come up with something called as the 52nd Amendment to the Constitution, which is also called as the Anti-Defection Law. That means you get elected by a political party and then subsequently you jump over to some other one. So how does that serve the purpose? That it's basically a loss for the political party from where you have got elected, and then you want to enjoy further. That is how you have these by-elections that they come every now and then, because these individuals continue to change. But as I keep telling, that anything that human made will also have its own limitations and error. Even this one, which was thought to be stopping all sorts of anti-defections, has failed to, because people have learned different methods to adopt. That's, I think, it's there in the Indian DNA itself. With whatever law that you come up with, there will be a loophole. This is precisely a reason why some of the tech giants across the world fear India and China, because we can produce clones, we can produce similar copies of anything from Microsoft to everything. It can make things very, very precarious. So in our DNA, it's very much there. You come up with something, you have a way, you have another way. That's how they will talk about. So that is the problem. Now, there are also amendments that include the amendment bringing down the minimum age of voting. This was important, though it's very, very political for that matter. If you look in, it was the age was 21 and then it was brought down to 18. And though it was that sort of a political game that was played, but nevertheless, a lot of people felt that they were good enough to make their decisions at the age of 18 and they deserve that one. And then we are all aware of 73rd and the 74th amendments to the Constitution, which led for the three-tier system. We have the Nagar Palikas, you have Gram Panchayats and all levels, some amount of decentralization and freedom that have been allowed for the local governments to happen. And then in the same period, there were also some amendments clarifying and expanding the scope of reservations in jobs, also admissions, which we saw the Mandal Commission playing a big role. Now, in particular, if you look in 38th, 39th, and the 42nd amendments have been the most controversial amendments. How much time do I have? Maybe 5 minutes?
Sandeep, sir.
How much time do I have? Maybe 5 minutes or 7 minutes?
Sir, you have, sir. Please continue. Thank you.
Okay, thank you. Now, these three amendments were made in the background of the internal emergency declared in the country in June 1975. This is very important that we need to understand why a right-based approach. That's why I like the way the poster was made. I was thrilled when I saw that. Though none of you are probably, this is my conclusion. I don't know whether I might be wrong, that none of you being students of political science or any of the allied subjects, but yet somebody had written there saying that right is not a privilege. And it's something that you own it. Yes, indeed, that's the spirit of the Constitution. That's the philosophy of the Constitution. Congratulations to those of you who could say that one. It's the same way. Asking right questions is the heart of democracy. So nothing to feel shy about it. Asking right questions is very, very important in democracy. That's how we survive. That's how we do a favor to the to democracy itself. Otherwise, democracy would collapse. We would all become sycophants. We would all become puppets in somebody's hand, or in local language, if I have to say, we'll end up becoming bhajana mandalis. Somebody says something and then we clap behind. So nobody is doing a favor to us for that matter. All is our right, and we have all the rights to take what we want to from the Constitution, as long as we are not violating it, right? So now the review of the Constitution itself was spoken about, but it has always created sort of ruptures. In 2000, there was a commission that was created to look at under the chairmanship of the retired Chief Justice of the Supreme Court, Justice Venkatachalaya. Now, opposition parties and others boycotted, fearing somehow the then political party which commissioned this one in India was fearing, or the opposition parties were fearing that they would change the scope and the face of the Constitution itself, which became very, very problematic. Now, while a lot of political controversy surrounded this commission, the commission stuck to the theory of the basic structure and did not suggest any measures that would endanger the basic structure of the Constitution. Now, you might be thinking, what is the basic structure of the Constitution, right? Now, basic structure of the Constitution is an interesting case that happened during Mrs. Indira Gandhi. Much prior to that one, there was a case that was associated with somebody called as the Golaknath and brothers. And in this one, when the state wanted to take away the land in the name of saying that it is for the public purpose and this much land is enough for an individual. They challenged in the Supreme Court of India that how can the state decide how much is enough for me? It's mine after all, and I have the right to property. And how can that be challenged? Then the Supreme Court of India had given a verdict saying that you cannot amend the fundamental rights of an individual and they are inalienable and you should allow it to happen. So they had approached through the constitutional remedies available in Article 32 of the Indian Constitution. And Ambedkar had said that one as the soul, heart and soul of the Constitution itself. If we don't have a protection to our fundamental rights while we enjoy or we have obstruction to it, he thought that was probably the disaster that had to come in. So then subsequently during Indira Gandhi's time, just prior to that one, before she came up with her Land Reforms Act, the state of Kerala had already introduced under EMS Namboodiripal. Now under EMS, when they started doing this one, there is a famous mutt called Edanir mutt. Recently, Keshwanand Bharati passed away. In fact, this was a news. And Keshwanand Bharati was a pontiff. He was hardly 19-year-old. I think when this whole thing happened, he was 21 and he approached the court through Fali S. Nariman and a famous jurist. And when they approached the Supreme Court, they had challenged some of these constitutional amendments that were given by Mrs. Gandhi or Mrs. Gandhi. He said that they should have the right to enjoy the property. They were capable of doing it, and there is no necessity for the state to decide how much they should have, how much should not they have. The Supreme Court was in a fix. Perhaps for the first time, they had a bench of 11 people sitting together because you had a formidable Indira Gandhi on one side who was hell-bent to say that when it is in the interest of the people, I will go any extent. I'll have the primacy of the directive principles over fundamental rights. Come what may, nobody should be in a position to challenge me. And she had also done certain things where she said there is no right for the judiciary to say anything that the legislature has done something to do with the welfare of the people. Now, in such scenario, the judiciary prepared itself to fight against the legislature. That means fight against the real executive. That's the Prime Minister of India. And when it had to happen, finally, after a lot of deliberations, the judiciary had to bow down, but it thought there should be a win-win situation. So what it did is it said, yes, you are supreme, because at the end of the day, even the constitution is created by the legislature, not by the judiciary. After all, the judiciary also functions, or the rights of the judiciary are also enshrined in the constitution. So in such scenario, we will say here that to find that there is no conflict between the judiciary and the legislature, we will arrive at some sort of a median. You can amend all parts of the fundamental rights, but you cannot amend the basic structure of the constitution, because Mrs. Gandhi in 42nd amendment to the constitution inserted the words socialist, secular and the integrity. Now here where she started going one behind the other, and then subsequently we also had many others which had come. So they feared somewhere that she would change even some of the fundamentals of the constitution. That means including the things in the preamble. If she could insert the word socialist and secular, were the constitution makers fools that they did not include socialist and secular? There was a logic behind why these two words weren't introduced. Then what was the necessity for her to? Though they arrived at something where they said whatever that is there in the preamble of the constitution as of that day, those things will not be touched. Rights of the federal states and few other rights have to be taken care of, and that would be called as the basic structure of the constitution. And they reversed their own decision on the Golaknath case and said that it remains null and void and the fundamental rights can be amended by the legislature. Now this is how they arrived at. They protected something, otherwise probably would all been doomed, because she went on to declare emergency. The proclamation of emergency created so much of problem for us, and she would have continued to be a dictatorial leader had not the judiciary intervened and saved us. So in fact, Justice Sikri and a group of people, and one luminary was also from this region by name Mr. K.S. Hegde. And his children are Santosh Hegde, and the other one is the one who runs the NITE group of institutions. And they all together made this particular decision. And subsequently, as a revenge to that one, Mrs. Gandhi gave away on or gave up on the seniority with regard to the judiciary, and she made a junior as the Supreme Court Chief Justice. As a resentment to that particular behavior, they all resigned from the judiciary itself. But whatever they did at that particular point of time in arriving at something called as the basic structure of the Constitution is what we have today. And on the Constitution Day, not just those people who created the Constitution, but who saved the Constitution also have to be remembered. So Justice Sikri and a group of people who did that one, standing against a leader like Indira Gandhi being so powerful, is commendable, and they have to be thanked on this particular day, is my humble submission. Now, 44th Amendment, if you look in 1978, a proclamation of emergency can be issued only when the security of India or any part of its territory is threatened by war or armed rebellion. Just imagine Mrs. Gandhi does all those things, and then she says that she can carry out anything, and she had puppet presidents in the sense whosoever she wanted to. They never would even ask her, is there a scenario that you need to have a proclamation of emergency to declare in India? Where is the law and order issue? Where is the real problem? She wasn't in a position to ask, or any of the presidents were. So Fakhruddin Ali Ahmed was the president of India at that particular point of time. She did not take consensus from her cabinet. She just walked up to him, and she got the proclamation signed, and the president of India declared. And only next morning at 6 a.m. she called all her cabinet ministers, and then she said she has already taken a decision. That's a sort of style of working that she had. So they were all damages that would have been. If the Constitution would not have been a living document, probably the 44th Amendment to the Constitution would not have happened, which happened during the Janata government between 77 to 79. That's when they sought. The Article 368 was misused by Mrs. Gandhi to amend the Constitution the way she wanted to, and then she also misused the provision that's given for the proclamation of emergency, due to which they said now onwards, if there is only a threat to the security of India or any part of its territory, or there is a war or armed rebellion, then only you can have proclamation of emergency, not for anything and everything. Why Mrs. Gandhi declared emergency? If you ask me, it was precisely for the simple reason that she had Jayaprakash Narayan and few leaders who opposed her, and they wanted to get rid of her because she had become dictatorial, and she thought the best way to stop them from the Ram Leela Maidan and the massive rally that they were carrying out, and then the witch hunt on all the political leaders, was through proclamation of emergency. Here where probably we need to remember that Constitution being a living document saved us all. Now, fundamental rights to life and liberty cannot be suspended even during the emergency. This is another thing that came because of an amendment. The right to property, a fundamental right, was deleted from the list itself, and now it's only a legal right. We continue to have it in another provision. Now, at the end, what I simply want to say is, when we talk about Constitution as a living document, it needs to be adaptive. And at the same time, if there are certain loopholes that were available in the Constitution, which were used by certain individuals to change the face of it or change certain philosophy behind the Constitution, there are provisions that allow the next regime, probably if the wisdom prevails, to bring back to normalcy, again, to make sure that it serves the purpose of serving the people of this country and their well-being, rather than that of serving certain groups or certain individuals who have this type of hunger towards power. Now, almost like a living being, this document, that's the Constitution of India, keeps responding to the situations and circumstances arising from time to time. Like a living being, the Constitution responds to experience. That is very important. It has now, a lot of things have changed. In fact, we have been seeing equal right to property. That's been another component that has come in. Women's right that has come in. We have seen recently the triple talaq, right? Otherwise, it was always seen as a sacrosanct. One of the blunders that we did in the beginning of the Constitution itself, if we could get rid of a lot of things that the British had given, we could have always gone for a uniform civil code, which we did not do, due to which it became a major problem. There's nothing called intervention within the religion or anything of that sort. Civil code is a civil code. If the philosophy behind bringing a Hindu code was to make sure that the women are empowered, why not the women should be empowered from other religions? So if that is the philosophy, then there is no necessity to be politically correct, and that's how triple talaq has served the purpose. And the women are super happy with regard to that particular community after a year of its existence. People feared that it's going to create communal violence, it's going to rupture the scenario within the country, it's going to change the face of the country. Nothing of that sort of happened. I think that's where the Constitution has responded according to the experience. It's given that flexibility to do so and has continued to be a living document. Now, even after so many changes in the society, the Constitution continues to work effectively because of this ability to be dynamic, to be open to interpretations, and the ability to respond to this changing situation. Now, this is the hallmark of the democratic Constitution itself. But at the end of the day, all we need to remember, that of the statement that you have put in your poster itself, the final authority lies with the people. People, their freedoms and their well-being constitute the purpose of democracy itself, and also the outcome of democratic politics itself. Thank you for your patient listening. I'm open to all your questions if you have any. Thank you so much.
Thank you, sir, for that wonderful talk. It was very educational and informative. I'm sure all the students, including myself, have learned a lot from you. We are very grateful for your wise words. Next, I would request Naman from the 10th course Baka to summarize sir's talk. Over to you, Naman.
Thank you, sir, for such an informative session. I would like to summarize what we went through in the previous session. So Sir began by informing us how the Constitution, being a living document, has affected our lives in India. Being one of the earliest republics in the world, the Constitution makers were always far-sighted, as they knew the Constitution would be a document which needed to be suited for entire country, irrespective of the people or the race. Sir also told that there is no constitution in the world that is perfect. Every constitution can be modified according to the changing situations. Then he referred to our very own Baba Sahib Ambedkar and the drafting committee, because of whom the constitution came into being. Then he told us about the Soviet Union and how the Soviet Union had 4 constitutions in the life of 74 years. After that, we were made aware about the 3 important factors that made a constitution a living document. Then we continued on to know about how the amendments are made in the constitution by giving us an example of formation of new states such as Telangana. He also told us about 3 of the most controversial amendments, the 38th, 39th and the 42nd amendments, as they were made in the background of internal emergency declared in India during July 1973. Then we found out about the 42nd amendment, including the words socialist, secular and integrity, which were in the preamble, and the 44th amendment regarding declaration of any type of emergency would be only if the security of India or any part of its territory is threatened by war. Even after so many changes in the society, the Constitution continues to work effectively because of its ability to be dynamic and respond to changing situations, which is the actual hallmark of a domestic constitution. This being an informative session, we would again like to thank you, Sir Nanda, for your delightful and invigorating speech. It was a pleasure to be here. Now over to you, Devanshi.
Thank you so much, Naman. So there are 2 questions in the chat box, which I would like to address. The first question being, monetary concession for backward class is okay, but why is there concession in marks for reserved candidates?
Why there is a concession in terms of marks?
Yes.
Okay, precisely. The idea is there in the question itself, in the sense these are historically backward groups, in the sense we look at certain groups have been privileged for centuries, but there are certain groups who are capable, in the sense as long as capability is respected, then one can argue saying that why should they be given? The problem here was they were capable, yet they weren't allowed because of certain what you say difficulties or certain ways of dealing with things for a very, very long time. So to subsequently take care of certain historical blunders, some of them have been done, but nevertheless, over a period of time, it started off with what should be the creamy layer. It started at 3 lakhs. It started at 4. It started at 6. It has started, now it moved to 8. Now they're going even till 11 lakhs. That means if an individual is capable of earning 11 lakhs per annum, there is no way that it can be or that those individuals need to be in that scenario at all. So that is flawed because that is extremely political. No doubt about it. But whatever that has been done with regard to the SC and ST, apart from the OBC, in the OBC category, there is a problem. I think that's been extremely political and they've been able to get it. And this is something that political parties have all come together. Nobody opposes it. In those type of issues, their salaries, in all these things, they all come together. But in other ones, this is comparatively flawed. So the question is absolutely valid, because as you keep changing the upper layer or the creamy layer to lakhs and lakhs above, it makes no sense at all. So economic backwardness is something that's associated with the backward classes, but not with the scheduled caste and scheduled group.
Yes, sir. So thank you, sir, for answering that question. The next question is from Dhairya Agarwal. Our constitution is too bulky and too complex for a layman to understand. In fact, it is considered a paradise of lawyers. Why so?
Bulky in the sense, the problem, as I told you, there was a necessity for us to bring a lot of diversity into the constitution itself, because this was a challenge. Because you had too many groups, every other group wanted to go away, every group wanted to break away from India, have their own country. All of you are aware, whenever we talk about Sardar Patel, this comes into picture. You had Hyderabad, you had Junagadh, you had Kashmir, you had even Travancore, that means Thiruvananthapuram in the south. Everybody wanted to secede from India and wanted to be independent countries. So what other ways that they could do? That means you keep it as elaborate as possible. You keep it much more open to what you say interpretations was the thought behind. In fact, comparatively, it is not that difficult to read except for certain sections of this thing. And paradise for the lawyers is, as I told you, that's the DNA of the Indians. You can't help it. Anything that you come up with, how much ever strict you tell, we all do that, right? Even we know that in Manipal, if there is a road in front of the police station, you have the cop standing to stop you without wearing a helmet or anything of that sort. You know, and 2 days you struggle with that. On third day, you come up with a new way. You come up with something or the other. I think innovation is in the blood, and then we all love being frauds. And I think that's the same thing applicable to even the constitution and the way lawyers are trying to exploit. If he doesn't exploit or the lawyers don't exploit, probably we don't call them lawyers.
Yes, sir. There's one more question. Good evening, sir. Do you think that our constitution needs a change and modification, as we are a dynamic and democratic country which constantly needs change and new laws to let the country shine? And new laws can be framed only after keeping the stakeholder, who are the new generation, etc., in the law-making process, as it is the need of the hour.
No, I don't completely agree with that particular statement that we need a new constitution. Certainly, we don't require a new constitution. This is what I keep telling. If the constitution fails, it is we who are failing the constitution. The constitution is not failing. Constitution has enough flexibility and it has got certain basic ethos for time immemorial. It's going to be, even in next 100 years, it's not going to change. I don't think your fundamental rights have to be changed. Come what may, whatever the scenarios are, and other things are open to what you say, amendments and other things which can be done for that, because having another exercise to change the constitution itself and have a fresh constitution can be an Herculean task. As I keep telling, this is not a simple country. It's not Lithuania or Latvia or for that matter Malta. This is a phenomenal country with the type of population that we have and the diversity that we have, and it's going to create a lot of controversy. So from my perspective, it certainly doesn't require, or India doesn't require, a new constitution, but whatever that we have, if we are able to even manage 20% of it, I think we all become better in our day-to-day life.
Definitely, sir. Thank you so much, sir, for answering the questions patiently. We come to the end of the question and answer session. Now, I would like to request Shubham from the 35th course BHM to present the vote of thanks for today's event.
A very good evening to one and all present here. This is Shubham Ghosh presenting to you the word of thanks. Thank you is a very small word to express a gratitude to such a honorable speaker like Dr. Nanda Kishor. It was wonderful of him to take his time out for us and impart a sense of knowledge within the students. I would also like to thank our respected principal, Chef K. Thiru, and our vice principal, P. Rajashekhar, for providing us such a platform to host the webinars. I would also like to thank Mr. Raghavendra for the technical support so as to let our webinar go on without any problem, and also thanking the faculty members. Last but not the least, I would also like to thank all the students of first year BHM, BACA, MHM, and MSc DAN for their patience and sincere attention towards this webinar. Once again, thank you one and all.
On that note, we come to the end of today's talk. Thank you everyone for your presence. Hope you have a nice evening ahead. Stay safe and take care.